All rise.
Somebody always has to be different.
I know.
Please be seated. We're going to go on and call the second case we have for this morning. We did do a shift in panel. At this point, though, I would like for the new justice that appeared on the panel to introduce himself and let us know from whence he came law school-wise.
My name's Larry Doss. I've been on the court since 2019. I went to Texas Tech for law school. It's good to be back.
And before I call the case, I want to thank the lawyers for agreeing to come up to the university to present argument. I know this is a transfer case. Normally, argument would have been held in Travis County. Hopefully, my geography is right, and we're probably a little closer to where you guys live than Austin is, but thank you for coming up here. The case we have now is 07-25-00016-CV, Danica Wilde versus San Angelo Stock Show and Rodeo Association. For Mr. Chapin, for the appellants. Are you ready?
I'm ready.
Thank you. And for the appellee? Okay. Thank you. Mr. Chapin, you've got the floor. Yes, sir.
Good morning. I'm David Chapin. I'm here for appellant Danica Wilde. And
Is it Wilde?
It's Wilde.
I'm sorry, I mispronounced the name.
It's logical mistake. And may it please the court.
Counsel.
Excuse me.
And you have water over there, hopefully, correct?
Yes,
sir. Okay.
In their separately published dissenting opinion in Phi Delta Theta Company versus Moore, Texas Supreme Court Justices Enoch and Hecht observed, and I quote, "As applied, both the reckless intentional standard and the inherent risk standard turn on an analysis of the nature of the sport in question and a determination of what risks are normally created by the nature of the sport. Designing and laying out a race course for match horse races that placed a fence in the path of the horses after they crossed the finish line and did not allow them enough room to slow down and stop, it's not a risk normally associated with match horse racing. The design and layout of the race course, as stated, created a dangerous condition that forced the riders to have to veer off to the left and into another fence. And while this was negligent, and while the Texas Supreme Court has held that farm animal activity sponsor negligence is an inherent risk, the course created by the Rodeo Association was not just negligent, it exceeded negligence. It demonstrated recklessness, and it showed a wanton disregard for the safety of those riders.
What conduct are you alleging or was alleged in the pleading to support that allegation?
The conduct of the sponsor or the conduct of the participant?
Well, either, I
Either.
guess.
Well, the riders, because of the design, after they crossed the finish line, didn't have enough room to slow their horses before hitting the fence. So each race they were forced to veer to the left towards another fence. And what happened in Danica's race And certainly not every race involved an injury, but this was just a matter of if and not when. In Danica's race, she was the horse to the right, and the horse to her left, as they crossed the finish line and were veering to the left, the horse to her left blocked her pathway in turning, so she had to cut behind that horse. And that left her an even shorter path to get to the side, towards the side fence to slow her horse. And she had to pull back forcefully on the reins, and her horse decelerated abruptly, and it just threw her forward into the side fence, and she was injured.
I'm glad you mentioned Justice Heck's opinion in that earlier case with Justice Enoch. Justice Heck later wrote the majority opinion in Lofton that was a unanimous opinion, and he talked about the application of this Farm Activity Act that's the nature of the Rule 91A motion. And there he said that he was trying to distinguish the Steig case out of the Austin Court of Appeals. And he said that if, for example, if you're on a horse and someone drives their truck into you while you're on a horse, that's not going to be covered by the immunity statute. But if in the process of backing up their trailer so that you could put your horse in the trailer, you're injured, then the immunity provisions of the statute would apply.
Yes.
Isn't horse racing, isn't there a risk of falling off a horse that's inherent in horse racing?
Of course there is. But in this case, falling off her horse was not the inherent risk that we're talking about.
Well, but back to Justice Heck's, I understand it's dicta, but back to his hypothetical, if somebody was backing up their trailer to get, so that you could put your horse in the trailer, and the horse got spooked and you got thrown at that point, it appears, at least under Lofton, the Supreme Court would say that that's included in the statute.
It is a farm animal activity, as was this race. But what we have here, Your Honor, it's a matter of, but for the presence of that fence, there's no veering to the left. But for the presence of that fence, those riders are riding their horses straight ahead down a clear pathway and slowing down and having as much room to slow down as it takes their horses to slow down.
But in Lofton, but for the presence of the trailer, we wouldn't have a spooked horse.
Well, in that case, it's a farm animal activity. They're loading the horse into the trailer. This is a case of an unnatural barrier being placed in the path of the raceway. And it goes beyond the negligence that causes the Farm Animal Activity Act limits on liability to come into effect. This is leaving that fence up and inducing those riders to come introduce their horses into that race is a reckless act. It's not just...
You mentioned reckless. This Rule 91 dismissal?
Yeah, yes, it's a 91A, Your Honor.
Is our focus just on the pleadings?
It is.
Does your petition allege recklessness?
We have alleged a dangerous condition on the premises. Okay. So we had not gotten that far at that point, Your Honor. This was just an original petition that addressed what happened.
Okay. So if your petition does not actually allege recklessness, can we consider recklessness? I understood that most of your complaint was founded on negligence, basically, or premises liability, or whatever, depending on the construction of the fence, which is kind of like negligence. But can we consider recklessness if it's not mentioned in the petition?
Well, yes, since it was introduced as a defense, and since the trial court based its dismissal upon the the application of the Farm Animal Activities Act, then recklessness is part of the act. So it's just an application.
Well, you said it was introduced as part of the defense. What defense? As a means to circumvent the immunity statute?
Yeah, I'm sorry, I couldn't.
You indicated that it was introduced as part of the defense, and I'm wondering what defense? Are you talking about in defense of application of the immunity statute, or?
No, the basis of the Rule 91A was that the Farm Animal Activities Act precluded everything in the original petition.
Correct.
And so therefore, in applying the act, recklessness is an element that comes into play as part of that, as one of the exceptions to the immunity.
Okay. Thank you.
Do you know where you alleged recklessness in your response to the Rule 91A motion?
It's in the reply brief. I think it's in section 4, issue 4.
In your reply brief to your appellate brief, or in your response to the trial court motion?
In the appellate brief.
Was it brought up in front of the trial court?
I did not, I was not the one who attended the hearing, so I'm not sure about how to answer that.
If it was not brought up in front of the trial court, can we consider it?
Certainly, because the order denying the motion, the order granting the 91A motion bases it on the Farm Animal Activities Act, that it provided immunity. Well, recklessness as one of the exceptions to the, one of the exceptions to the 87.003 inherent risks. 87.004 spells out 6 exceptions to that. And 87.0044 is whether the sponsor acted with willful or wanton disregard. And so therefore it applies if the 87.003 inherent risks apply, then if there's an application of one of the exceptions, it applies just as well.
Questions, since you're talking about the statute, and correct me if I'm wrong, but does not the statute state that immunity pertains to colliding with an object?
Excuse.
Does the statute say that the immunity includes colliding with an object?
Yes.
And I don't want to be, I don't want to trivialize the situation. I don't know the extent of the injuries. I don't know if you described, I don't think you described them in your briefs and such, but was the collision, what caused the injuries was collision with the fence, correct?
Ultimately, yes.
From being thrown from a horse.
Ultimately, yes.
Why wouldn't the collision of the fence fall within the statute saying immunity applies?
Well, among the elements of negligence, we have proximate cause and but for causation. And but for the presence of that fence, she never veers to the left. She just rides her horse straight ahead and slows down.
But it's clear that the injuries, according to your petition, the injuries arose from the collision with the fence.
Ultimately, the final act out of the whole series, yes, she was thrown into the fence.
Well, why wouldn't a collision with the fence be a collision with an object for purposes of the immunity statute?
If not for the reckless conduct and the willful disregard of the safety of the participants, then it would be.
Okay.
Let me ask the question a different way. Suppose she had remained on the horse and the horse had crashed into the fence. I think under those circumstances, it clearly would have fallen under Section 87003 sub 4. In this case, her act of pulling back on the reins of the horse and the horse stopping is what ejected her and crashed her into the fence. Is there a meaningful difference between those two things under the statute?
No, I wouldn't. I don't think so, Your Honor. The statute is a comprehensive cover of liability, and what it goes back to in this situation is yes, she was participating in a farm animal activity, and there are inherent risks involved, and they're enumerated in 87.003. And in appellant's brief, since the court didn't elaborate as to which part of the statute it was granting granting the motion to dismiss on, I had to go through and cover every possible way it could have been granted. So every one of those of the 5 enumerated limits on liability in 87003, none of those come into play in this case. She didn't run into another horse. Nobody collided. None of the riders did anything negligent. They were being forced to ride to the left.
Well, 87032 talks about the unpredictability of a farm animal's reaction to a sound, a sudden movement, or an unfamiliar object. If the horse recognized the fence, wouldn't that be a horse's reaction to an unfamiliar object that would put you under subsection 2?
Yes, I would just have to say we wouldn't know in this case if the horse saw the fence, if that's what caused it.
In the clerk's record, I'm trying to remember reading this. Did the court grant you leave to file an amended petition?
They did.
Was there another amended petition that was filed after your first amended?
Only the first amended.
It looks like the first amendment amended was filed a few days before the Rule 91A motion. So I just wondered if there was any other effort to amend after that.
There was not.
Was there a request for leave to amend after the court ruled on the 91A motion?
No, it was not. It was before, so that we could get the motion before the court.
In many situations, when you're dismissing on the basis of jurisdiction, the general rule is if you can plead facts that would give the court jurisdiction, you got to give them leave to amend. If something like that, the court should give you leave to amend, excuse me. Is that a similar situation here, that the court should have sua sponte given you leave to amend to state a claim with that defeats immunity, so to speak? We asked for, the basis of our motion for leave was to be able to file the amended petition within the 7 days prior to the hearing. So, yes, the court would have had no basis for denying the motion for leave. I'm talking about after the court acts, so should it have given you another opportunity to amend?
Yes, there would have been a basis for that, but we didn't have, we didn't believe that there was any need for anything further in the pleading. I mean, I wasn't present at the hearing, and so, but I think the ruling happened at the hearing.
Obviously, we're a transferee court. We're receiving this receiving this case as a transfer from another court. And under Midschke principles, we've got to apply any binding authority out of that court, either from the Supreme Court or from the court that's transferred it to us. The Stieg, I think Stieg's out of the third court. Does that have any viability anymore? Did the Supreme Court overturn it? Or what do we do with Stieg now?
Stieg, well, Stieg has authority except for the language. What the Supreme Court didn't completely overturn Stieg. They in Stieg they made the appellate court made the assertion that the 87.003 limits on liability inherent risk didn't apply to a farm animal activity sponsor. And in Lofton versus Lee, the court specifically disapproved of that language. Otherwise, it didn't touch the decision. Actually, Stieg, there was a petition for review that was dismissed. So the decision stood.
But in Lofton, I thought Lofton undermined Stieg's holding. You know, it seemed to me that Stieg held if there's some sort of user intervention that causes negligence, like in Stieg, putting too big a saddle on a horse that was intended for a child, Stieg said, well, that isn't covered under the act because that's something a user did and that's not inherent in the activity. And I thought Lofton came back and said, not so fast, we're going to, there may be negligent activities that are part of the inherent process of this activity, and so we're not going to say there's no immunity there.
Right. I think what happened with Lofton is that in Stieg, there was no assertion under 87.0044 that there was reckless, willful, and wanton disregard. It was all that it was sponsor negligence for negligently putting the saddle too loosely on the horse. And so, yes, Lofton would have undermined the decision because the decision in Stieg was based on sponsor negligence. And the court said, well, there's no sponsor negligence. So even though it didn't directly overturn it, it would have undermined what the result was, yes. But the two things have different bases because there was no accusation of, or no allegation in Stieg of reckless disregard.
Thank you, counsel. You do have 5-minute rebuttal.
Okay, thank you.
May it please the court.
Counsel.
And my name is John Mark Ho, counsel for San Angelo Stock Show and Rodeo Association from San Angelo, Texas, and I do appreciate not having to drive through Austin traffic to come argue this case this morning. So thank you, Your Honors.
Can you do me a favor and direct that mic a little straighter, maybe towards your mouth? Sometimes it picks up and sometimes it doesn't. So.
Okay, my mother accused me of having one volume, and that was loud, but as I've gotten older, maybe that's a problem.
Thank you.
May it please the court, the Lofton versus Lee case is the case that this court should look to in deciding this one, and I think it's controlling, and I think the court's already identified that as being an important decision in this case. The issue, I would like to address a couple of the questions that the court asked opposing counsel, which was about the reckless or the willful misconduct or gross negligence. I don't believe, and I haven't looked at the petition in a while, but I don't believe that was ever alleged at the trial court. I think that first appeared on appeal as part of an exception, or at least the argument about an exception. I don't recall that ever being something that was discussed at the 91A motion hearing, or that being pled.
Are we limited to reviewing the case and disposing it based upon what was presented to the trial court?
I believe so, Your Honor. I believe any argument regarding that is waived. We didn't really raise that in our brief, but since the question's been raised here,
All of the cases I've looked at have all been summary judgment cases, though, where there was at
Correct.
least the benefit of the full development of the record, at least for summary judgment purposes. If we found out after the fact that the organizers said, well, let's add a little intrigue to this activity by putting a fence at the end and seeing how fast they could stop, that would tend to get a little closer to the willful or wanton activity. Is that something we should send back and at least allow the development to take its course before we do something on this?
No, I don't think so, Your Honor, because, and as we've identified in our brief and arguing here today is, I'm happy for the court to accept at face value the allegations he's made. He does not allege in his petition that a fence was put up in the middle of a race course. What he alleges is that this took the cinch roping fiesta, which this match race was a part of, takes place in the rodeo, in an outdoor rodeo arena that is owned by the San Angelo Stock Show and Rodeo Association. There is no allegation in the complaint that they shortened that track or that they put a fence in the middle of that arena. What he describes is, and what he described here today is, what he's talking about is the end of the arena, the fence around the arena where the participants compete. And he's saying that alleging that there was not sufficient room to stop. There's no allegation that any other participant in one of these match races had that problem. There's no allegation in this case that the other participant in her race had any ability to stop. So I think just by taking the facts as alleged in the complaint, not necessarily as he wants to characterize them today maybe, but as they're alleged in the complaint, there is no basis for the case to go forward just based here on immunity. Because I think there's a couple of issues I think with regard to that, because fences, we argue, is an inherent risk of participating in that type of an activity. When you're entering as a competitor in a competitive race in a rodeo arena, in a roping fiesta type of event, those are taking place in confined spaces, in confined arenas. She was there. It's an open and obvious condition. It's not in the record because we're not getting into facts, but the fact is that it's an open and obvious condition that she could have seen. It's not an unnatural barrier. It's not anything that was put in place to shorten the track, to make it more challenging in that regard. And there was no evidence, there's no allegation in the record that the fence was even of a type that could have been removed and removed to allow an open track. What they're essentially arguing is that the only way you could have a race of this type is if it's just done out in the open and there's no limit to how far the horse can run. We don't believe that's the law, and we believe that the inherent risk of that activity is that it's going to take place in that confined space, and the inherent risk of it also goes to the fact that inherent risk is you can get hurt by hitting an object.
Let's talk about Lofton a little bit.
Okay.
What happened in Lofton obviously was two horses were trying to cross a boggy area and a vine touched one of them on the flank and it caused the horse to startle, and that's what threw the rider and it caused the injury. And I can understand under those circumstances that the vine causing the horse to startle was inherent to riding a horse. That's what caused the injury. Here we've got an arena, and the arena has an outer barrier. And the outer barrier potentially, at least according to the plaintiff, potentially causes a danger to horse riders, but it also would to motorcycle riders or runners or anybody else who had an event in that arena. that seems to me maybe that it's not necessarily inherent in equine activities, but it is something that is just the nature of the facility. Does that take you outside of Lofton?
No, I don't think it does, Your Honor, because I think in Lofton, the issue that they're complaining about in this case is essentially that the Stock Show and Rodeo Association was negligent in laying out the race, in choosing the course, in choosing the track that which the participants would take, and that they negligently didn't leave enough space for her to be able to stop in a straight line. The issue in Lofton was not just the inherent risk of crossing a boggy area and choosing a course. The evidence in Lofton, I believe, if I'm correct, was that there were alternative courses that she could have chosen to take that would not have exposed to that risk. And it was the negligence not only in not judging her ability to ride a horse, but in choosing that path. And what Justice Heck, and the court held in Lofton is that negligence, let's just assume for the fact that Stock Show and Rodeo Association was negligent. That negligence by the sponsor of the activity is in and of itself an inherent risk of the activity. And therefore, we think Lofton controls. We don't think there's really any difference between that. This particular, it's outside the scope, but this particular rodeo is not where the main rodeo takes place. It's a smaller arena close to it. That's an outdoor arena. The another question that was asked, that the court asked, was whether plaintiffs should have another opportunity to amend. I would argue no. Opportunities to amend are offered typically when the facts of the case are such that if an amendment would cure the problem. In this case, there's no amendment that could cure the problem related to the inherent risk. There's no other facts that they could allege.
Well, if in amending, he would argue that the way it was constructed, the arena was constructed, created was reckless, more than negligent, if you will, was bordering on malice or something like that. That may get around immunity. Should he be given willful, wanton, et cetera? Should he be given an opportunity to allege that?
Well,
Proving it is something else, because we look at the face of the pleadings and, under Rule 91A, but
well, his own pleadings, the facts, I'm just going by Your Honor, by the facts that he alleged in it is that I don't know what facts he could allege that could bring it within that, because his own facts allege, this is the first time they ran such a course. There's no evidence or allegation that this had happened before or has happened since. And so from that standpoint, I'm not really sure what facts he could allege. I suppose if the court wanted to have it go back down to have that opportunity, then I think we'll be back with a Rule 91A motion to dismiss on that, because I don't.
Is that something that has to be included in pleadings? I'm thinking along the lines of other defenses that come up on occasion, like, I don't know, limitations periods or something. You allege immunity in this case, like you've been alleged in a defense for limitations. Does that shift the pleading back to the other side, or can they simply just say the defense doesn't apply?
And I'm not sure I'm understanding your question, Your Honor.
Ms. Wilde's attorney is arguing for an exception to the immunity that you asserted as part of your Rule 91A. I'm wondering if that follows sort of along the lines of an avoidance defense that wouldn't require them to do anything to replead, or if that's something where repleading is necessary.
I don't think repleading adds anything to the case. I'm not sure I'm understanding your question, so I'm going to try to answer it the best that I can. Essentially, what the exception that we're talking about is if the sponsor was essentially grossly negligent in the activity. And in that case, you would have to get to willful, conscious, we know this is a danger, but we're going to do it anyway type of standard. I don't think that there's any facts that they've alleged. In the facts are not going to change that they've alleged. Those are the facts that they've alleged, and they've alleged it twice. They had the opportunity when we filed the motion, the Rule 91A motion to dismiss. We filed the motion. They filed a response. They filed an amended petition right before the hearing with that opportunity to change those facts. So if they could have alleged those facts, they certainly could have done so at that time. So that's already been offered. I don't see what granting them an opportunity to amend that now and take another shot at it based upon allegations of gross negligence, which they could have already brought up at the district court when they amended.
In your view, is the inherent risk that triggers the statute the risk of colliding with the fence?
Yes, Your Honor.
Is it the risk of being thrown from a horse?
Yes, Your Honor. It's all of those.
Does the horse have to collide with the fence?
No. No, we don't think so. I mean, and it's the same for any other type of animal activity. In my brief, I use the example, of a rodeo rider. He can be injured by being thrown from the animal. He can also be injured by being thrown from the animal into a fence in the same type of arena that we're using here. Or a horse going out of control. Those sorts of things in a roping event. All of those types of things are things that are inherent in that risk. You know that that's what you're going to participate in. You're going to participate in an activity where you're racing a horse against someone else at full speed. You know that you have to stop. You have to make those decisions. You know that the horse might spook. It might do something different. It might throw you. Those are the inherent risks of that activity, which is why the legislature created this specific immunity statute to govern those, because of the risks that were inherent in it. This is not an assumed risk kind of argument case. It's a specific immunity granted by the legislature.
I asked opposing counsel this a question, and I will pose it to you as well. What do we do with Stieg? Is Stieg still good law? Was it overturned?
No, I believe Steed is not good law, and I think the Supreme Court and Justice Heck specifically essentially said that in the case. There may be some elements of it that it cites to a general rule of law, but its rule in that case, it was essentially arguing that, or the argument in that case was that the fixing of the saddle was not, an inherent risk. He was negligent in doing that. That's not an inherent risk of it. And in Lofton, the court specifically said, no, that's not the case. The case is that even the negligence of someone saddling a horse is inherent in the risk that's going to happen when you're engaging in that type of activity. There's just too many factors to it, which the legislature recognized, which is why they created it. I don't think the Steed is good law, at least not for the purposes that plaintiff is arguing.
Just curious, in another setting, if I were someone who grew up under a rock and I've never been to a rodeo, never rode a horse, never saw a horse, how could I determine whether or not something was an inherent risk? Is that a more factual basis, or as a judge I could just say it's an inherent risk? How is that inherent risk normally shown?
How is the inherent risk shown?
Yeah.
Is that the question?
How do you decide something's an inherent risk? And I think colliding with an object, I think the statute says is an inherent risk, kind
Yes.
of. But it also says those are some, including.
It's not exclusive. I mean, the statute gives a specific laundry list of things that are. That is a specific one. The risk of being thrown from a horse, those are specifically set out.
So if it doesn't fall within those 5 instances or examples, would it be more of a fact question that it's an inherent risk?
It could be, Your Honor.
Okay.
I'm saying there could be a fact issue related to whether something is or is not an inherent risk, if given the circumstances, if it falls outside of one of those. I'm not saying that it couldn't, but I think as a matter of law, if the court finds it, I think it's a question the court has to decide about, is that an inherent risk of that activity? And for example, if you have someone that's going to a rodeo, I don't believe the statute applies to someone that you're describing that might go to a rodeo who's never been to one, doesn't know anything about horses, who's sitting in the stands. They're not engaging in an equine activity probably at that point. So I think that would be a different set of circumstances. But once you decide and participate, you pay the entry fee, you're going into the competition especially, that you think you're you're going to do well and you're going to perform
I'm
it.
going to ask you to invoke what your mom told you about you.
Oh, volume?
Yes, sir.
Okay, I'll try to say. I think essentially under those circumstances, there could be someone attending an event like that that's not engaged in an inherent risky activity, such as a patron who's just watching. But once you decide to enter into the competition, to enter into the arena, so to speak, in the words of Teddy Roosevelt, you are part of the competition, and that's where the inherent risk comes. That's all I have, unless the court has any other questions.
Thank you, counsel.
Thank you.
Rebuttal, sir?
May it please the court.
Counsel.
I'd like to address Justice Doss' question in regard to Lofton versus Lee. The distinguishing between whether the vine that touched the horse's flank and caused him to throw the rider, and whether there was any distinction between that and leaving the fence up in front of the racers. And I think there's an acute distinction there, because in that, in the analysis the court did, and I'm sorry, I don't mean to point at you. I talk with my hands, so I'm not pointing at you.
It's just how you point.
Okay. The analysis the court did in Lofton was that they talked about how these were all naturally occurring situations. The boggy ground, or it could have been the sound of an owl, or various things that, like the vine touching the horse. The horse reacted to it. It was the horse's inclination to react to it. The distinction is in our case, you have a sponsor that makes a decision to leave a barrier up in front of the racing horses. I mean, that's their decision to do that. And that
I would have agreed with you based on the decision in Stieg, except in Lofton it also says, on the other hand, had Lee been struck by a horse trailer while unloading the horse she was to ride on the trail, her injury would have resulted from a risk inherent in equine activity because the two were directly related. We're not talking about naturally occurring risks then. We're talking about a horse trailer backing into somebody.
But what they also say is that if Lofton had run a truck into Lee, then it wouldn't have been. But because they were loading the horse to participate in the activity, that made it a farm animal act activity, and so therefore it fell under the inherent risk.
So maybe that is what gives us the outer limits of where Lofton stands for. But at least under those examples, I mean, I understand they're dicta, but at least under those examples, given that your client was on the horse, riding the horse at the time she was injured, doesn't that lean more closely to the example of the trailer and not the horse, not the truck just directly running into her?
I would say no, because they're putting on these match races at this event for the first time. And as you discussed with opposing counsel, the people paid a fee. Putting on this race induced them to come out and run their horses in these races. And as a result of that, they're entitled to some trust in these sponsors to provide them a race course that's safe. And I would like to point you to it's one of the exhibits to, I think, the first amended petition, that it's the materials that the event sponsors sent out to the participants. And there's a text that the main person, and I forget his name, sent to Danica Wilde. And it says, on the map, it shows that they're going to have 250 feet between the finish line and the fence, but in his text, it says approximately 250 feet. So we don't really know how much distance they actually had to slow their horses before hitting that fence. And it could have been, if it was 230 feet, that would have been a huge difference. And we just don't know.
Do we get to take that exhibit into account, given that we're reaching this on a Rule 91A motion?
Yes, because the dismissal was of our based on our petition. So, yes, that's where the analysis comes from.
But there's no evidence. The judge is not supposed to look at any evidence, just the pleading.
Well, I mean, it was an attached and as an exhibit to the petition, so it was part of the pleadings. Thank you. All of my previous experience has been at the 1st and 14th Court of Appeals in Houston, and so I thank you for the opportunity to come out here and do this in a different spot.
Of course, the 1st and 14th are good courts of appeals, but the 7th is always the best.
Well, I'm finding that out today. Thank you.
Thank you. Your case is submitted, and you are free to go. And again, thank you for coming up here. We really do appreciate the opportunity to present in front of the students. And we will be in a recess until this afternoon.
All right.